And now, CL 650 presents your source for leading-edge news and information on today's hottest products and services. This is Experts on Call.
Good evening. I'm Tony Giaventu, your host of 650 CL's Talk About Strata. In the studio this evening, I have Adrienne Murray from Hammerberg Lawyers. She's a strata lawyer. She used to work as the Deputy Superintendent of Real Estate for the province of British Columbia, and she has an incredible amount of experience in dealing with strata law and the relationship between strata councils and strata owners. Welcome, Adrienne.
Thank you. Good evening.
We're going to talk about hearings tonight, which is a pretty big issue. And in light of the fact that the Civil Resolution Tribunal amendments were basically entered into the House yesterday afternoon, this is going to become a much bigger thing for strata corporations because they probably are going to be faced with a more formal scrutiny over their process of enforcement of bylaws and hearings with owners. So let's just actually walk people through bylaws. We'll walk them through the enforcement process. We'll walk them through what hearings sound like, what they should look like, and maybe some of the crazy things that people do. We also have a bag full of emails that we're going to respond to some of them as we go along. So that'll be a help for us. So
okay.
Hearings.
Well, first of all, let's just be clear that we've got the processes of the Civil Resolution Tribunal don't actually impact the hearings. But I think what we're saying here is that up until now, or up until the Civil Resolution Tribunal takes effect, owners really had very few places where they could go for recourse if they weren't happy with what went on in the strata. Coming into force of the Civil Resolution Tribunal's processes, I think will change that dramatically because owners will now have a place that they can go to have the conduct of the strata corporation scrutinized. So in doing that then, I think it's really essential for strata corporations to sort of take a few steps back and say, all right, now let's make sure that our processes are appropriate and will withstand any scrutiny that may occur through the Civil Resolution Tribunal. And one of the opportunities for owners to really have their issues resolved is through the hearing process. So there's really two ways into a hearing under the Strata Property Act. One of them is Section 34(1) of the Act itself. And this was a provision that was added to the Act not all that long ago that said that an owner that wished a hearing before council was permitted to apply in writing.
But that was a change because the hearing process was originally part of the bylaws, which many strata corporations stripped out when they amended their bylaws because they didn't want to do hearings.
Exactly. So the initial draft of the Strata Property Act, and I can't remember when this was changed, but 3 or 4 years ago, I think possibly. 2009 was when the major changes occurred. So up until 2009, this was a provision in bylaws, and as you say, if stratas didn't want to be bothered with them, they would just take them out of the amend the bylaws to remove it. So in response, the legislature put it into the substantive provisions of the legislation so it can't be amended. So what the legislature is saying is an owner has a right to have a hearing, and what the Act requires is that they must apply in writing, stating the reasons for the request, and in that way request a hearing. Now, the Strata Council must hold the hearing at a council meeting within 4 weeks after the request. And then if the purpose of that hearing was to request a decision of the council also has to give that decision within 1 week after the hearing. So there's some guidelines and some pretty tight time frames around which a strata council on behalf of the corporation must respond and hold the hearing and then respond.
So whether an owner is going to, under the tribunal system, test whether the hearing process has been conducted right or not is going to really come down to whether the strata has followed some of the basic principles of the Act. So a hearing is part of any judicial process, for example. And so when you are in court, that is essentially a hearing. And it's the opportunity for both parties to be heard, and to state their case, to be able to argue, prevent evidence. So the hearing process, though, in the Strata Property Act is a little different than that.
Well, when you say an opportunity for both parties to be heard in a court, that's an adversarial process.
Right.
What we're talking about in the hearing here isn't necessarily, at least a hearing under Section 34(1) isn't necessarily adversarial. It's an owner wanting to get the attention of the Strata Council, saying, I have a problem with this, or I want this repaired, or I want to make this alteration. I want to explain to you what my problem is, or what my question is, or what my request is, and I want to do it verbally.
So that's just a generic hearing.
That's right.
For any item under the Act, whatever the owner thinks it may be, they can request a hearing under Section 34 of the Act.
That's right. All they have to do is put it in writing and give the reason. So and then the council must hold a council meeting to hear the applicant. Now, challenges obviously then arise with timing.
Right.
So the council holds their next council meeting, and that's when this hearing can occur, and that may or may not be convenient. So we would like to think that the parties will work together to set a time, and it may be that this hearing doesn't work for the person making the request. It may have to be the next hearing. Notwithstanding that, though, the council has to hear the applicant within 4 weeks of the request. So the Act doesn't say what happens if the council says, yes, here's your hearing date, it's next Monday at noon, it's within the 4 weeks, the council's met its requirement, but the individual making the application works Monday to Friday.
Right.
So must they take a day off? Well, and perhaps maybe that's, if this is a council that only meets during the day, maybe that's something that has to be done. So there'll be accommodation, but I'm going to suspect often the accommodation is going to be by the person making the request for the hearing. They're the one that wants the hearing. So they're going to have to probably make the biggest accommodation to make this work and make it happen.
And that occurs when a person is asking for a hearing on just, again, any general subject that comes up in their strata that they feel they need to bring to the attention of council.
Exactly. There's
Right.
there's no particular categories of issues. As I say, I can be there to be complaining about the noise from upstairs. I can be there to complain about the smoke from my neighbor's cigar. I can be there to ask for permission to take down the wall between the living room and the dining room. I mean, so it could be
Right.
it could be a wide range. There's no particular categories where an owner may or may not request hearing. It's just wide open. Just all you have to do is give the reason why. Now,
So a good example of that would be a few weeks ago, an owner I spoke to has got a bunch of owners together. They're unhappy with the fact that in their landscaping, which is quite extensive, that the landscaping companies are using leaf blowers. And the noise that is generated in their community is quite disruptive. And so owners are asking that leaf blowers be banned. But that comes at a price for the Strata Corporation. There's more manual labor involved, which of course will cost more money for the Strata. But that would be a hearing example. So if we were just doing that in a generic hearing level, I'm the owner, I've requested a hearing about this issue. What does the Strata Council do?
well, the role for the Strata Council is in the word of what we're doing here.
Right.
And it comes down to something really quite simple, but yet amazingly not always complied with. So the role of the council here is, in a hearing, is to hear the owner's issue, whatever that may be. And if it's one or multiple owners that want to talk about the noise, the disruption of the sound of the leaf blowers, evidence of how the effects of the noise of leaf blowers impacts people, people that may have babies that are complaining about it, whatever the facts are around the issue, this is what they're going to bring to council. Now, it's not council's role to necessarily make a decision at that moment or to get into an argument with the owners. It's not this isn't necessarily adversarial.
Right.
It's for the council to hear. They may have questions. They may throw out some possibilities. Well, if it was limited to the hours of between 1 and 3, would that be better? They can throw out some of those things, but it's not intended to be a debate. And in fact, I think council members shouldn't expect to be cross-examined on an issue. They're not there to answer on behalf of the strata. They're there to hear.
So gather information.
Exactly.
Really. So to be able to facilitate change. It's interesting where you say the hours 1 to 3 because the person who called actually runs a counseling service out of her home and between 9 and 12 in the morning sees clients. And so the leaf blowers are a huge disruption for her specific personal needs. And her business that she runs from her home is permitted under the Strata's bylaws. So it's kind of a counterintuitive function that happens in their community. So obviously, understanding the impact that occurs, the hearing process is viable. So we did the hearing. The council listened to her, had the discussion around the frequency of the leaf blower. She expressed her concerns, her with respects to her home-based business. Meetings over, hearings over. What happens next?
The Act requires the Strata Corporation and the Strata Council that's had the hearing to provide a response. If a response has been requested, then the Strata Council must provide a response in writing within 1 week after the hearing. So it's a very, very short time frame for the council to make a decision and communicate that decision in writing. Now, I recommend to councils that if at all possible, once the hearing concludes, the person leaves the room, debate it, make your decision now. If we adjourn to make a decision and meet again to discuss it, chances are the week's going to go by. So
Right.
let's just make our decision. And it may be that our decision is we can't accommodate the request because we don't have enough information. For example, in the case of the leaf blower, the council may say, well, we would like to check with our landscaper to see if they can change the hours that they service our property to the afternoon so it doesn't interfere with the morning schedule. Is that going to be possible? Can they do something other than leaf blowers? And if they can, how much more is it going to cost? So there may be additional information that the council will want to get. So at the moment that they're giving the first response, they may have to refuse the request, but indicate that they are continuing to examine the issue. But in any event, they really need to have that response out within 1 week and put it in writing.
So I'm this owner. I've requested the hearing. Council have set a time for me. I can attend. Who can I bring to this hearing with me?
Well, again, the Act is completely silent on procedure, process, who can come. In my view, you can bring anyone that you like, and I think that what you have to do is let the council know that's who you're bringing. So in your request for the hearing, in your indication of why you want the hearing, I think it would be appropriate to say, I will be bringing my lawyer, I will be bringing other owners who are witnesses, I will be bringing the people from across the street who are also opposed to the leaf blowing. So whatever it may be, it's all part of the hearing. It's all part of the strata gathering information, and it makes no sense to me. And I hear it from time to time where strata council refuses other people to come or refuses the legal counsel for the owner
Right,
to come.
right.
That makes absolutely no sense because they're really there to hear, to gather information, and the more information, the better.
Right. So, it's interesting because we hear the horror stories from people who say, well, my council refused to let my lawyer attend, or I have 2 witnesses and the council refused to let me attend, and they told me I only had 5 minutes for the hearing process and I couldn't go any further. So, what kind of, when the strata sets so many really tight parameters on those types of procedures, what kind of risk is the strata taking?
Well, I think the risk is clearly that it's not a hearing as contemplated by the Act. The Act talks about and defines a hearing as an opportunity to be heard. And if you limit me to 5 minutes at the end of the meeting and in mid-sentence you tell me my time's up and you've refused any additional information or any other people that I think should attend, then I don't think you've heard me.
Right.
And at this point, of course, the owner could apply to court if it was a serious matter about a hearing. But there's other things an owner can do. For example, with the leaf blowing, we may then gather a petition of owners and with 20% of the owners demand a general meeting. We might amend the bylaws to propose an amendment to the bylaws to prohibit leaf blowing. We can also pass a resolution under the Act that directs the Strata Council by majority vote. So Strata, this is not an area that I see used a lot, and frankly, I think it's an underused section of the Act.
Very much, yes.
Because 50% of the owners can direct the Strata Council. the direction could be to direct the landscaper not to use a leaf blower. So in reducing the ability for the hearing process, I think the Strata Council is running a risk that the problem could escalate, more people could get involved, more people could get upset. There could even be a resolution that these council members are withdrawn or removed from council by majority vote. If they're indicating that they're not prepared to listen to the owners, who they are there to represent, then it's not a stretch to say that owners may collectively feel that this is not an appropriate council.
Well, and I think that we'll see more pressure or requirement for hearings, because one of the provisions of the tribunal system will be the advanced solution explorer that people start with, and they will identify as they go through a diagnostic system, have you had a hearing with your strata council? Have you had an opportunity to resolve this before going into the tribunal system? When they move into the case management stage, the same questions are going to be asked. Have you actually had a hearing with council? Have the parties had an opportunity to find some resolution here before moving forward? Civil Resolution Tribunal is about finding solutions for people so that parties can consensually live together in a much better way. So, you know, I think we're going to see a lot more pressure on hearings.
That's a good point. I think we will. I think, again, it may well have been an underused provision of the Act, and maybe a misunderstood provision. I mean, I think for a lot of councils, it's an all or nothing type of proposition in many ways. And when an owner comes with a problem or a dispute, I think part of the council's job is to see if there's a way to resolve the issue, and that's a broad-based resolution.
Yeah, exactly. I'm Tony Giventu, your host of 650 CIL Talk About Strata. Adrian Murray, a lawyer from Hammerberg Partners, is in the studio, and we'll be back in a few moments.
This is Experts on Call on CIL 650.